going to start by going through and introducing ourselves, and then we'll kind of get started. My name is Brittany Frandsen. I'm an associate. I work with our litigation group. We do a little bit of trademark and patent prosecution as well.
Fraser, Roy. I'm a shareholder, Workman, Nydegger. I've been there 20 years. Patent prosecution, trademark, copyright, anything that is IP related. Stay away from litigation.
I'm Callie Rogers. I'm of Counsel, and I do some transactional work. I do some business development information and contract review and those types of issues.
I'm Brent, Lorimer. I'm a shareholder at Workman. I sue people, mostly. I do litigation primarily in the patent area, although we do also trademarks and copyrights, trade secrets, non-competes. I've been there since 1985. Excuse me, 1987. So I've been there a long time.
And the way this is going to work, I'm going to be the moderator, and these guys are going to be answering questions. But and then at the end, we'll open it up for some Q&A. Just to start, so we can kind of get a feel for who we have in here. Is anybody in here a student? Okay. And then, has anybody in here ever filed a patent application, or a trademark application, or a copyright? Okay. That's good, just so we can kind of get a feel for where we are. So we've got kind of a broad range, so I think we're going to start by having Fraser just give us a quick overview of what a patent and then trademark and a copyright is, just a quick overview.
Okay, so basically think about intellectual property as a way to gain assets for your company, your business, okay? Each of those IP assets is basically a negotiated agreement with the US government on saying you have certain rights, and because of those rights, you have exclusive opportunities to do things. You can exclude others from doing certain things, okay? So from a patent standpoint, you've got an invention or a claimed invention that you can exclude others from making, selling, offering for sale, exporting and importing the claimed invention for a period of time, usually 20 years from the priority date, okay? So that's a big stick that you can have, an asset you can gain to hit people over the head and keep people out of the marketplace. Okay, trademarks is an identifier of source. Okay, think of Nike, think of Apple. You know that when you pick up something with an Apple sign on it or a Nike sign on it, you're getting a particular good or service of a particular quality from a particular source. Okay, so that's an identifier of source, and you can gain goodwill. It's another asset that other people won't be able to use it, and it will bring your customers to you. They know that they buy an Apple product and get a certain quality from a certain source. A copyright is an asset that can be a sculpture. It can be the notes you're taking right now. It could be the notes I wrote. Okay, it could be an artistic work. It could be a sculptural work, and it's an authorship fixed in a tangible medium of expression. Okay. So the copyright is basically a written document or an artistic work or something that has rights to it that other people can't do things with it. Okay, so just like a patent, I've got certain rights. Copyright, you've got a bunch of sticks or rights that you can exclude them from displaying it, from copying it, from presenting it. So that's a kind of a high level description of sort of the main intellectual property assets you can get.
One of the things that misconceptions that people have about patents is that if I have a patent, then I have a right to practice that patent. I have a right to put that invention into the marketplace. It's not set up that way. It's sort of backwards from that. You have the right to prevent others. But if others have patents that cover your widget, and they're before you, they may have the right to prevent you from using your widget. So it is the right to exclude. It's not the right to practice. They're two very different concepts.
And then, so Fraser, at what point in a new company's development should it start seeking that kind of protection?
Sooner rather than later. Because of certain rules, certain with patents, let's start there, you cannot publicly disclose and then file for a patent application more than 1 year after that public disclosure. So say you take a product to a trade show. 1 year after that, You cannot.
Or a Huntsman venture.
Or a Huntsman venture, right? You give a public disclosure of the invention or a product containing an invention that you like. If you present it without a confidentiality agreement, and we're going to talk a little about that later, but if you do that without a confidentiality agreement in place, you have 1 year in the United States to be able to get patent protection. Make sure you remember that outside the United States, you're unlikely to be able to get any patent protection if you public disclose it first. We have a what's called a grace period associated with our regs. Most other countries are called pure novelty, which means it can't be published first before you file your patent application.
And the other thing you have to remember is that we changed recently in the United States from a first to invent to a first to file country. So if you have an idea that you want to get a patent on, you are best served by filing that application quickly rather than waiting, because if somebody else gets ahead of you in the queue and they have something either the same as your invention or they would make your invention obvious, that can be a problem. So don't dawdle.
Yep. And the same thing goes along with the trademark on that side, because you want to get your rights into a federal registration as soon as possible. You gain trademark rights through use, okay, but that use is going to be dependent upon where you're actually using it. So if you've got a trademark and you're only using it in Logan, you may only be able to get certain rights there through common law. If you want to get nationwide rights, you have to file for a federal registration, and the sooner you do that, the sooner you put people on notice through the federal system that you are saying, I own certain rights in that trademark. Otherwise, you're going to be very limited in your rights and the access and the geographical region you can protect.
And so as we talk about acquiring IP rights, as your company is small, you usually, I think, just have your own company keep the rights and acquire that. But as companies grow, a lot of companies will start IP holding companies. So Callie, can you kind of tell us kind of what an IP holding company is and what are the benefits and the downsides of doing it that way?
Yeah, so an IP holding company would be a company that is formed strictly to hold IP, as that suggests, or hold other assets, but for our purposes we're going to talk about IP. So it would be owned by or have sister ownership with, or parent ownership with your company that's doing the business, right? So some of the benefits historically have been tax benefits. There were a lot of tax benefits specifically in Delaware and Nevada. Some of those are going away in different states. So that's kind of just something that's you have to consider, and that would be something you want to look at your specific situation with your accountant or someone in financial planning that would help you decide if the tax benefits were right for your company to do that. Another benefit is that it shields your assets from your company and keeps your assets from your company separate from the assets of the actual intellectual property. So that if you're sued for, you make a widget and the widget causes some problem and you're sued for that, your IP assets aren't going to be targeted as part of that lawsuit. Some of the drawbacks sometimes, it can be sometimes harder to protect your IP and to enforce it if it's held by a holding company. It's not as directly back and forth with the business. So
one of the other things that happens in litigation is that if you sue somebody who has a lot of patents, they have a tendency to want to sue you back. So if you whack them upside the head, they're going to get out their patent and try and whack you back. And if the company that does the suing is an IP holding company, it doesn't make widgets or anything like that, then they can't whack that company back with their patents because they don't make anything. Now they might sue the sister company that does the widgets, but that's one of the reasons people move IP out of the mothership and into this IP holding.
Since we've kind of already started to brush a little bit on infringement, Brent, you can answer this for us. How do you instruct your clients to monitor infringement of their intellectual property?
Well, that's an interesting question, especially today, because so many things today are on e-commerce platforms. And you've got Amazon, you've got Alibaba, you've got all these different e-commerce platforms all over the world. And one of the great things about those platforms is you can get anything delivered to your door in 24 hours. And you can get a wide selection, usually at a pretty good price. One of the difficulties is that there are now crawlers or bots that go onto the web and they figure out which are the best-selling Amazon products in a given category, or on Alibaba or somewhere else. And then they begin supplying those sometimes Amazon has something called an ASIN. It's an Amazon something identification number. And some people start using your images to sell their product. And that can cause all sorts of problems in the marketplace. And so there are companies out there, the short answer is there are companies out there, there's one called Mark Monitor, there are others, that for a fee will, if you know where your biggest problem is, either one of these big e-commerce platforms or others, they will for a fee, they have software that goes out and checks the web. You give them a description of what you're looking for, or names that you're worried about, trademarks that you're worried about, they will go out and they will give you a regular report about who the bad guys are. That's one way to do it. Another way to do it is, in small companies it's a little harder, but in larger companies, if you have a marketing person who's got sort of his ear to the ground about who's doing what in the marketplace, you want to pay attention to that. You want to go to trade shows. You want to figure out what your competition is doing, not only so that you can stay abreast of it, but so that you can figure out if they are infringing either your trademarks or your patents, then you can be Johnny on the spot. Because if you wait, you're much less likely to get an injunction if you wait. They have this, what they call irreparable harm. This will sound odd coming from me, but my translation of irreparable harm is your hair is on fire. And if you want to get an injunction, you have to go to the judge and say, Judge, my hair is on fire, and it's going to burn my head, and I'm going to be the ugliest man on the earth, and you got to fix it right now, you got to stop it. But if you know about this problem and you don't do anything about it, it's pretty hard to argue that your hair is on fire. So stay abreast of it through one of these monitoring services or through your own people. You know who your competitors are. Watch them.
So as an addition to that and tying that with the holding company, in some larger companies, what they'll do is they'll have their holding company be watching them as well, but they'll also have pending applications. So you may have your initial core technology patent, let's say that. But it's very detailed on what options you have or what alternate configurations you have on your product. Maybe you have a series of enhancements or improvements to that. If you can keep pending applications throughout as long as you can from a financial structure, whether it's when you're returning investment, if there's a way to keep those pending for longer, once you've identified your competitor that may be infringing, or maybe you think they may not be infringing, but it's really, really close, and you look through your claims and you think, if I had a claim that said this, maybe it would be better argument for litigation. If you maintain pending applications, that you can then go back and craft those applications to read on top of those individual competitors, if you have the priority dates, if you have the benefits and the disclosures that you could read on top of them. So as you build your portfolio of patents, consider how long you want to keep them, and not just file one and let it grant and then you're done. If you're a VC coming into a company, you look a lot better if you've got granted patents and pending patents that go back to that original date, because it gives them flexibility to craft claims the way they want to. If you've only got granted patents, then you sometimes are not it doesn't look as good sometimes, depending on the circumstances.
And the idea is that you can mine that application for new claims. And as Fraser said, you can cover stuff that comes up down the road.
So then, Fraser, kind of along those lines, especially if you're a smaller company just starting out, you don't have a lot of resources to put into your IP, but you'd like to do something like that where you keep your protection extended as long as you can. How do you prioritize and kind of strategize for your IP protection?
It's really going to come back to your finances and what's most important. You go for your core technologies first. Okay, you look for what patent can I get to protect my core technology. Then I go from that is there an enhancement, or is there a competitor that I may target later on? Is there a structure? Do I want to file a provisional application to get some things in place to start off with? Am I planning on filing internationally? Because that's just really expensive. If you don't want to file internationally, then you just stay in the U.S., then maybe it's just picking your provisional, then a utility, then stretching your utility out as long as you can with respect to time periods to allow during prosecution to keep it pending enough but not incurring any costs. It really is going to come down to focusing on what's most important for the company at that time, and that's a business decision of, what's the core technology? What do I really need to prevent other people? And then trademark side, that's your identifier of source. That's your thing that tells you who your company is, what your product name is. Getting those ones early. Trademark applications are typically a lot less expensive than patent applications. And so if you can nail down your corporate name, not with the LLC or the Inc., but your widget name or whatever, get that as your trademark early, then you can start spending money on building that goodwill, building that brand, building that knowledge base or that source of goods and services. You can do that earlier, and then it's going to be a cheaper option than patents. Then you have to also balance, am I going to do a patent or am I going to keep as a trade secret? There's going to be certain things that you might just want to keep as a trade secret, put in the security procedures with access to your trade secret, and who has the swipe cards to get in, is it in a safe, is it in a secure, encrypted database, whatever it might be. You put all those places in for a trade secret protection rather than patent protection. Just understand that when you're deciding between patents and trade secrets, the trade secret dichotomy is huge, because if you can reverse engineer it easily, you're probably going to want to go the patent route. If it's something that a competitor cannot reverse engineer simply, then maybe that's a better option, right? And some of the chemical arts, things will change based upon the combination of the chemicals, right? And you may not be able to reverse engineer that back out. So that might be a trade secret that's benefit. Think about Coca-Cola. Right? How long's Coke been around? Well, that's a trade secret on their recipe. Yeah, you can't patent recipes anyway. But that concept of, hey, I can keep something secret longer than my patent, so maybe I can take that route. So those are kind of the benefits and the things to look at.
One of the other things you might consider is there are two kinds of patents. There's utility patents and design patents. Utility patents are typically for the way something works, an apparatus. It's got a whiz bang over here, and it's got a gizmo over here, and it's got a razzmatazz down here, and they all connect and they spit out stuff. The other kind of patents is a design patent. Design patent is a patent on the non-functional ornamental appearance of an article. The thing about design patents is they're a lot faster to get, and they're a lot cheaper to get. And you might say to yourself, well, so what? Well, ask Samsung about that question. Apple sued Samsung on design patents, among other things, and at last count, the verdict was like $500 million. So if you've got a product that has a distinct appearance, and that product appearance is important to the way that it sells, not the way that it works, but the way that it sells, and it's recognizable, and you want to get, how long does it take to design patent, Fraser? 8 months?
Yeah,
6, 8 months?
real quickly.
And a utility patent, on the other hand, can take years. So if you've got something that you're interested in that's got a cool appearance to it, and it's non-functional, which is another question, but and you want to have some protection right away, this is one way to get it fast, and get it cheap, and you can take it out there and start whacking people with it. If there's somebody who's knocking you off, that's one way to do it quickly and less expensive.
Okay, so let's say now we've got our IP, we've got some different options of things we can do for it. One thing people do to monetize their IP is they'll license it. So Callie, can you kind of talk to us about some things that you should include in an IP license and other considerations with respect to that?
Yeah, so in a license, you're allowing someone else to use your IP while you're keeping the ownership of it. So you can talk about, one of the main things would be exclusive versus non-exclusive. So if it's an exclusive license, I'm only licensing to one person, or the only person that can use it. If it's non-exclusive, then I can license it to everyone. So that would be one of the terms in there. And then length of the license would be another term, whether it's perpetual, meaning it's ongoing, or whether it's a term of years or a term of, I guess you could do a term of months. Another one, exclusivity and perpetual. So the duration would be part of the term. So in a license agreement, you talk about those items. You talk about how they can use it. If it's a license agreement for a trademark, you talk about how they can use it and what areas they can use it, if they can only use it for certain something. So talk about the different uses. You talk about some of the remedies. You talk about what happens if they breach that agreement. Typically, you'd want to include a provision that you could get an injunction, go to court right away. The hair on fire, talk about that.
I'm gonna be famous for that.
Yes, you are. It's great. I like it. Any terms that you want both parties to understand, you want in your license agreement. Make sure that everyone knows. And then, if you're deciding exclusive or non-exclusive, you want to decide, what's beneficial. Do you want to do it for lots of different people, or can you make more money if you're doing exclusive and you're fine with just having that exclusivity relationship for a while? So there's not necessarily right and wrong to all these different areas. It's just something you need to make sure that both parties are on the same page, and that you, as the IP owner, we're going to assume right now, are protecting your IP, and you're making sure that you're considering the relationship now and what you're going to want to do in the future.
And one of the things you need to consider is who your licensee is and who they might later sell to. So you have an assignment provision in this agreement or a non-assignment provision. You may want to make the license personal to the licensee, because you may not, let's say you have an non-exclusive and you're a small company and you're just licensing to somebody else to generate revenue. Well, that may be fine if they're also a small company, but let's assume that someday they're purchased by Procter & Gamble, and then all of a sudden you're competing with Procter & Gamble for your own invention sales. That's not a good idea. So you got to be careful about assignment. And on this exclusivity thing, you have to put in your license who can enforce the patent, because the rule in patent law is this: you either have to be the owner of the patent to enforce it, to sue on it, and that's typically the inventor or who he assigned it to. Or you have to be an exclusive licensee, and you can either be a virtual assignee where you have virtually all the rights in the patent, or you can be an exclusive licensee and you can sue if the inventor joins with you. So you have to have language in the agreement that spells that out. Who can sue? What are the terms of the suit? How do you split the cost? How do you split the rewards if you win? And who gets to control prosecution of ongoing applications? Who owns improvements? Let's say you license. Say I license my patent to you, and this is a swell patent, but you're an innovative soul, and you take that technology and you make it even better. You add 4 or 5 things to it, and it's even cooler. Well, who owns that? You or me? Well, you have to put that in the license, or it's a good question who owns it. Because if there isn't a provision that I own it, you may own it. It may be my patent may dominate your patent, but you may still have something that you can stop me from doing. So you got to spell all this stuff out in the license. License agreements are often much simpler than they should be. You need to look at these nuances or you can get in a world of trouble. I just finished litigating one where they gave this license to this guy, an exclusive, and he started suing people all over that the inventor didn't want him to sue. And it was a big problem. He sued Kim Kardashian. And the inventor was not happy about suing Kim Kardashian because, as you might expect, she sued back. And so
a little more money than
well, he's paying my bills. So you really need to look at those licenses carefully, and let me, this is not a very kind thing to say, but don't use LegalZoom to draft your licenses. I mean, it is not a one-size-fits-all deal. Go to somebody who knows what the heck they're doing and get some good advice on the licenses.
Speaking of suing and lawsuits, so say licensing fails or someone doesn't try to get a license from you, and they're knocking off your product or they're knocking off your trademark, Brent, how should different companies, I guess, respond to that? Off of the spectrum from small companies with not very many resources to large companies with everything.
Well, if you're a large company with everything, you hire a really mean and nasty lawyer and you just go beat the crap out of him.
You call Brent.
That's what you do. But first, obviously, if your client, if you as a company owner think that somebody's infringing your patent, the first thing to do, your lawyer is going to ask you, well, give me a sample of the infringing product. Because you need to look at it. This is not something you do sort of off the cuff. Patent litigation is very expensive. I mean, just unbelievably expensive. And so you need to get the product, and you need to do a careful analysis and compare it to the claims and see if it really does infringe. And if it doesn't, maybe you take Fraser's suggestion and you get some claims in a continuation application that do cover it. And then you nowadays, if you can, you would want to sue for an injunction. Let me tell you why that is. First of all, if you get it, then the door slams shut and that person is out on the street with his product and he's done. Okay? Now, injunctions are hard to get, but it's important that you try to get one nowadays if you can, because of this thing called an IPR. It's an inter-parties review at the Patent Office. As part of the latest revisions of the patent laws, they created a bunch of post-grant proceedings where anybody in the public can go to the Patent Office and say, you know, I think you guys messed up when you granted that patent. It's really a piece of junk, and I think we ought to invalidate it. And that's where every defendant goes. Not every defendant, but most defendants go. Because it's cheaper. You can do one of those for $400,000 or $500,000. May not sound cheap to you, but in the real world it is cheap. And you can get it done in 18 months, which is lightning fast compared to patent litigation. And they have a 70% kill rate for patents. So if you're a patent owner and you want to stop somebody, the thing you want to do first is just smack them right in the nose as hard as you can, as fast as you can, because if you get an injunction, that IPR is out there in La La Land somewhere. It's at least 6 months away. And this guy, in the meantime, has got a huge problem because the presses have stopped. So that's what you do if you have the money. Let's assume that you're either a medium or a small company, medium-sized or small company, and you don't have the money to go out and get an injunction or do those sorts of things. One of the things you can do is you can go to them and try and negotiate a license, try and monetize your patent. That's one option. Or you can hire contingent fee lawyers. There are lots of those around in patent cases. They used to all go to Texas. That's changed now. Now they're in Delaware. And they will take a chunk of the return, but it is a way to finance patent litigation that people who can't afford it use. And you know, there are trade-offs, but it's not a bad deal to get a reputable one who's good. And if you have somebody, let's say you have somebody on Amazon or Alibaba or someplace like that, patents don't do much good on Alibaba and Amazon because the people who are looking at whether to take down the site or not are not legally trained and are not sophisticated enough to figure out whether this thing is infringing or not. But if you have trademarks, they love trademarks on Amazon and Alibaba, and they love copyrights. They have these policies that if you can show them that you have a trademark that this guy is using, they will shut them down like that. And it's really effective. Copyright, you have what they call the DMCA, the Digital Millennium Copyright Act. And if you have somebody who's infringing your copyright, you can do a takedown notice that you send to the ISP, to whoever their internet provider is, and they will take that thing down and they will do it like yesterday. Now, the person who has the site that is the problem can send out a counter notice within 10 days, and if they send out the counter notice, you've got two choices. You can either sue them or they go back up. But a large percentage of the time, the people who are putting out these knockoffs or the copyright violations are not very sophisticated, and if you shut them down, they'll go away. So talk to your lawyer not only about the big, expensive sledgehammers, talk to them about things that you can afford.
And then the flip side of that, Brent, let's say someone comes to them and says, hey, you're knocking off my product or my trademark, what should they do?
Go hire a good lawyer. No, I mean, again, the thing to do is get the patent, talk to your lawyer to get the copyright, or get the prosecution history of the patent. But the one thing you do not want to do, you absolutely have to pay attention to this. Do not ignore it. Because if you ignore it and it's found that you infringe and that you didn't have a good reason to believe that you weren't infringing, you can get treble damages assessed against you. You can get attorney's fees assessed against you. Do not ignore it. Pay attention to it. Now, it may be a great opportunity for you to innovate, because the way it works is you have this patent claim and it has elements A, B, C, D. You got to have all those to infringe. Well, so maybe you can come up with an idea that says, I've only got A, B, and C, and I don't have any. Make a better product, maybe you get your own patent. Use it as an opportunity, but do not ignore it. Because if you ignore it, you could be in a major pile of kimchi. You could be in big trouble.
Okay, so we've just got a couple more minutes left for the panel, and then we're going to open it up to questions. Stepping back a little bit, back towards acquisition of IP. One of the things people run into is, am I creating this thing myself, or am I having an independent contractor do it? We're going to have Callie talk about that a little bit and just talk about different considerations for independent contractors versus employees and agreements that you need to have in place and things like that.
Okay. So yeah, if you're a small business, that's probably a real consideration is which one you're going to use. There are some, so if you have someone that you need to be there all the time, you want to control their work, you want to have, they're going to be working in your office, you probably want to have an employee. The IRS really has tracked down on companies that were using independent contractors in place of employees when they really should have been employees, because when you have an independent contractor, you don't have to pay the benefits that are required, you don't have to pay taxes on that, and the employee with the independent contractor needs to pay taxes. So there are certain ways that it's easier to have an independent contractor. So first thing you need to consider is how much you need that person to be working for you, and how much control you want over what they're doing, how much control you want over the time and the place that they're doing it. You can have control over the work product with an independent contractor, but if you are saying you will be in the office from 8 to 5 and you'll be in this office and here's your computer, that needs to be an employee. If you're a small company and you don't need someone all the time, then you might be able to have independent contractors rather than employees. A lot of times you probably have both. But an independent contractor, you would be contracting with them, so you need an agreement for a certain project or a certain length of time. They get to choose where they're doing the work, on what times they're doing the work. You can have deadlines to get the projects to you, but if they want to work in the middle of the night, typically that's something that, depending on the project, you probably have to let them do. So the independent contractor would not pay their employment taxes, and they would be responsible for that side of things. But on the flip side, you don't have the same element of control as you do with an employee. So this is really, in the IP context, this is important because there's a work for hire doctrine where an employee creating something that it's assumed that the employer is going to have that IP, but with an independent contractor, you need to make sure that you have strong provisions in your agreement that are setting out exactly who's going to own that intellectual property. And that could vary because some some independent contractors, when you contract with them, you might be contracting because you want to use some intellectual property that they have already created. And in that sense, the contract between you needs to set out how you're going to use it and make acknowledgments that both parties understand whose IP that is. But if you want them to create IP for you, you need to have that. You need to have provisions in the contract with them assigning the intellectual property to you. So you need to make sure that you have an attorney looking at that to make sure. And again, that's going to be different. You don't want to just look it up online because your situation, there's no two contracts for an independent contractor that are going to be exactly alike. There's similarities, but you want to make sure that if you're having them create intellectual property for you, that there are provisions in the contract with them that it is assigned to you, and that they will, there are terms that say that they will do whatever is necessary to assign that and to prove that and to file anything that needs to be filed with that.
So on the contract side, just a quick note. The first time you look at the contract is when you and the independent contractor or you and the licensee are happy. Right, you're eager to get into the relationship, you're eager to do the work, you're eager to get things taken care of. The next time you look at a contract is when something's gone wrong and you hate each other. Okay? So make sure that when you're doing your contract, you just go again to take the time, think through the issues, think through who owns what, why they're going to own it, what's going to happen if this occurs, what happens when this occurs. And good attorneys will walk you through that, and they'll try and pick out, okay, what about this situation? Well, you're saying you want to do X, Y, Z. Well, what happens if X prime happens or Y prime happens? How do you want to deal with that? And so they're able to work through those issues with you to try and expand and enhance and make the contract better for you, and better for both sides usually, because then as long as the terms are exact and concise, usually when you do get mad at each other, you say, look at the contract. You go, okay, yeah, contract says that we're done. You don't move into the litigation or anything else after that. So
you can get a lot more accomplished when you're both happy with the relationship. At the beginning, you can set the terms, and you're both going to be happier if you can think through the things so that you make sure that at the end of the day, you spelled out everything so that it's easier to agree at that point.
Yep.
Okay, so we've got a little bit less than 10 minutes for questions. Obviously, there's a lot of information out there. This is a very broad topic. So if you have any questions about anything we've just said or anything about intellectual property, we'll just take people one at a time. Right here.
So you kind of mentioned this already, but I was just wondering how IP protection has changed since the internet and information age has come about and that more dominates the marketplace. Of course, your product is so much more accessible to anyone who lives in a block internet.
Well, I think there's a lot more infringement now. There's the proliferation of these e-commerce platforms has made it so much easier to get products out there, and you don't have to have big quantities of inventory. You can do it just in time. You can just ship what you need. And so it requires a lot more policing than it used to. And frankly, the atmosphere in this country for patent owners is less favorable than it used to be. You guys know what patent trolls are? Patent trolls are these guys who go out there and they buy patents, they don't make anything, and then they just sue everybody and their brother. I mean, they got a patent that they think covers everything from a fax machine to a toaster, and they sue hundreds of people in Texas. And the advent of the patent troll has caused Congress and the Supreme Court and others to have the pendulum swing way far to the side of the non-patent owners, and it is harder to enforce patents now than it has ever been, I think, in the history of our country, which I think is a bad thing. But sooner or later, it will swing back. I mean, it just takes a long time.
And that's why the DMCA was created to do some of the copyright side. And that's why you've got a lot of the ICANN proceedings and other proceedings you can do through the ISPs to bring down sites that are maybe using copyright that works or trademark, using your trademarks, you can bring them down. So those are why Congress has created those kind of mechanisms to help as well.
And those, I think, are much more favorable to the actual
Yep.
than they used to be.
Next question? Okay.
So another thing with the internet is that there's just so many more products out there. How would you go about searching? Let's say I have a product and I'm trying to find out if it's already patented or if it's already protected. How would we go about researching that when it's not necessarily all going to be on the internet? Maybe they haven't created the product, they just have a patent for it.
Well, that's a different animal, because you're not really searching for the product, you're searching for the patent.
Yeah.
And so there are, in every country, most industrialized countries around the world, there are patent offices. And you can either pay for, or you can do yourself, a search at the U.S. Patent Office. You can go on to www.uspto.gov, and they have a search engine there, and you can search for it. You can also do that, particularly in Europe, in the EPO, they have pretty good search facilities. And it's not perfect, because, you're limited by the quality of your search terms, but you can get pretty close to what's out there, and then you look and see, this is the problem, and you can sort of whoosh things a little bit, but you're not really looking at the whole internet, you're just looking at the different patent offices, and depending on where you want to sell, you may not have to look at all of them. If you're only looking at the US, then just look at the USPTO.
So you need to look at the USPTO, you can do Google Patent, you can search on Google Patent. Another way to do it is look and see if there's instructions for use associated with whatever product there is. Sometimes on the instruction manual, there'll be a patent number saying this product is covered by such and such patent. Sometimes they'll actually emboss it on the product themselves. You can go to the corporate website for the individual, for the product itself, and sometimes they'll have those listed under the legal terms and conditions. Maybe you have a patent section you click on and it'll list their patents, and that can speed up the process as well. There's lots of different resources to try and identify patents associated with particular products.
Next question?
How important are confidentiality agreements with employees, and what can you kind of limit?
They're a very big deal.
Yeah.
They're really important. I think you want to have your employees sign a confidentiality agreement. If you set out what is confidential information, how they can use that. Typically, you want to say they can only use it for purposes of their work. You can't use it for competing products. And you want to do it probably not just with the employees, but when you have independent contractors, you want to have confidentiality agreement, if you have a license agreement, you want to have some sort of confidentiality. It would be relevant in a lot of different contexts, but you want to set out. I typically, if I can get a confidentiality agreement to be perpetual, I would want to keep the information confidential. And there's terms that you can say. There's exclusions of what is considered confidential information. If it's disclosed by someone else, it's not protected by an agreement, or if it's independently discovered or something like that. Those things are good, but I would say with employees, you definitely want to have.
Do you want to have that drawn up by an attorney?
Yeah.
Okay.
Yeah, and the other thing that you can do in that same agreement, as long as you got them there signing, you might as well extend the season of felicity. You ought to put in non-solicitation provisions. For example, one of the things that happens in small startup companies and tech companies is that somebody becomes unhappy, and so they decide they're going to take their marbles and go somewhere else. And they don't just take their marbles, they take their marbles, and then they find their neighbor who they like, and that other person, and they take out your company. So you want them to agree that they will not solicit the departure of other employees to compete with you. And then you can also include in that agreement, if the circumstances warranted, a non-compete clause. Now in Utah, non-compete clauses are now limited to 1 year. You can't have more than 1 year from the time of termination. And they're also limited to situations in which you have a legitimate interest in whatever it is you're trying to protect. It can be goodwill, it can be trade secrets, it can be customer lists, it can be all sorts of things. But if you've got somebody who is the Ronald McDonald of the company, or somebody who has access to important information, you ought to get a non-compete. You really should.
And that's especially true if you're going to go down the trade secret route to protect some of your intellectual property rather than patent route or a copyright route, because that's going to be your first exhibit, is to say, hey, here's my confidentiality agreement that I gave to every employee to protect our trade secret, and this person walked out with it.
One thing to consider when you're having an employee sign an agreement is to make sure that they know that Utah's the work for hire state, so you have the right to hire and fire at will. So it's not will state, sorry. Unless you are setting up a contract term of employment, you want to make sure that they understand that the term of the non-compete, for example, or different provisions of the contract are not a term that you have to employ them for that whole time. So unless you want to make sure that both parties, saying you're going to work here for a year. But in Utah, you don't have to have a reason to fire someone. There are certain reasons you can't fire someone, but so that's one thing to consider when you're making the contract.
I think we have time for one more.
Do you have to have all of these documents separate, like non-compete, confidentiality? I don't know what. Some of my independent contractors, they can make money by commission. Like, are all these things, should they all be separate documents, or can I just say, here it is, read it over? And how flexible should you be with that if they are not happy with one of the terms?
Depends on whether, on the first question, if you have a big enough wheelbarrow, you can put them all in one wheelbarrow. I mean, you can put everything in one agreement. It may be to your advantage to put them separately, because sometimes they have some states that are called blue line states, where they will, if they find one provision of the agreement unenforceable, they can fix it. Other states, they say if that's unenforceable, the whole thing goes out the window. So you have to be conscious of where you're operating and what the law is. Now, with respect to the second question you asked, the first one was...
Depends on your power. Depends on how much power you want. Yeah, how reasonable you want to be to them. If you're hiring as an independent contractor, you can say, no, that's my terms, take it or leave it. Or if you really like the person, or you really like their skill sets or what they got, then you can maybe adjust it a little here or there. It really comes down to a business decision tacked on with what legal issues are going to come by you modifying to what the independent contractor wants.
It's a risk-reward thing. I mean, if you have somebody who you think is dynamite and just wonderful, and you really want to keep them, that's great. Well, everybody's happy and saying kumbaya, but it might not be so great if they want to walk out the door and take your stuff with them.
Yeah. Can you make the confidentiality agreement last way longer than when the non-compete is up?
Typically, you can do 3 years. I mean, you can make it longer than that, but the problem with confidentiality agreements is that confidential information oftentimes becomes stale. I mean, if you have access to my customers 15 years ago, and you go out and do something with them, so what? But if they're, within the last 6 months or 2 years or something like that, it's a different story. So you can write it for whatever you want. Whether it's enforceable or not is a different question.
Okay. Thank you.
I think we're outside. Thank you.
Everyone, thank you.